Hello and welcome to Season 3, Episode 1 of ARBinBRIEF, a practical video guide on handpicked arbitration issues. My name is Deniz Özyıldız Gedik. I'm part of the ARBinBRIEF team and I practice international arbitration with 𝗥𝗕𝗙𝗏 Law Office based in Istanbul. I will be moderating today's episode on do's and don'ts as an arbitrator in pro se arbitration, featuring Gisela Knuts, who is an independent arbitrator at Helsinki, and Lauren Norman, who is an associate at 𝗥𝗕𝗙𝗏 Law Office at Istanbul. I'm sure most of you have already heard the term pro se arbitration, especially if you've worked in one before. But if you have not, pro se arbitration means a party representing themselves in arbitral proceedings without the assistance of an attorney. If you have ever worked as a counsel against a self-represented party, you may think that the case will be very straightforward and it will run smoothly, but unfortunately, this is not usually the case, and it can be quite difficult to run an arbitration when the counterparty is not experienced in arbitration practice. This is when you rely on the arbitrator's intervention to ensure a smooth procedure for both parties without the interruption of the party's right of justice. And today, our experienced speakers will give valuable advice on how to run a pro se arbitration as an arbitrator. With that said, let's start with my first question. What issues have you experienced in your cases which involved self-represented parties? Lauren, would you like to start?
Of course, thank you. So a common issue which I have seen is that self-represented parties are often unaware of the correct procedures to follow. You know, in arbitration, we have a lot of procedural norms and standard practices, which as counsel, we're very familiar with, but with self-represented parties, most of them will have never done an arbitration before, and they won't know the standard procedures, and this can cause some problems. To give a couple of examples, in one case that I was involved in, during the hearing, the self-represented party had included in their opening presentation a screenshot of a document which was not on the record, which the other party naturally objected to. It was quite unfortunate because this document had been an attachment to an email which was on the record, but the attachment itself was not, and the self-represented party didn't understand that they needed to include all the attachments as an exhibit as well. But considering that it was so late in the proceedings, we had to explain to them that they could not rely on this document, which was, you know, they weren't very happy about that, but there's not much you can do at that stage. In another case, the self-represented party had submitted exhibits in the wrong format. They had submitted Word documents and links to websites which were not publicly available. So we had to request them to submit their exhibits as PDFs. This party had also submitted an expert report which did not include any of the expert's credentials or the instructions which they had been given. So it was unclear who this expert was or what they were involved in. So a big issue is a knowledge of procedure. But another issue that I have experienced is that self-represented parties tend to focus mainly on the facts of their case, but they don't really rely on the law or the contractual provisions, or they don't fully substantiate their claims. There can be problems when self-represented parties feel very strongly that they have been morally wronged and treated unfairly by the other party, but their contract or the governing law doesn't actually support their case, or they just haven't substantiated their claims for damages. And as an arbitrator, you can't make their case for them. So it can be very difficult in that respect. So those are just some of the issues that I've thought of.
Thank you for these examples, Lauren. I'm sure most of us have faced similar problems with the counterparties in our cases as well. And Gisela, what about you? Have you experienced any similar or different issues as an arbitrator?
I have, thank you. And first of all, thank you for inviting me. I'm super happy to be here because when you've been around for a few years in the arbitration scene, as I have, it is not that often that you come across topics that are new, that you haven't spoken on at any conferences before, but this is the first time I have been invited to speak on pro se arbitration, so I'm really happy. I agree with all that Lauren said. I think as a practical tip, the best thing you can do when you're an arbitrator in a pro se arbitration is to have be very specific when you draft your PO1. So, because as Lauren said, one of the key issues, of course, is that there's not a level playing field as to what is best practice, how do we run the proceeding, what do we do? And in order to make the proceedings run as smoothly as possible, my advice to anyone who is an arbitrator in a pro se arbitration would be to do a pretty granular PO1, regardless of sort of the legal culture where you're in, because we know that, PO1s can go from a couple of paragraphs to 30 pages. I would opt for maybe not the 30 pages, but still a fairly granular version of the PO1 in pro se arbitrations, exactly for the reason that that is a neutral way of inviting also the self-represented party to familiarize themselves with the practice. Plus, if it's in PO1 and they still don't follow it, it's easier for you as an arbitrator then to, for instance, tell the parties, or, well, first of all, it's easier because you can recap before the hearing, for instance, please refer to section so-and-so of PO1, where, it's stated how we run the proceedings at the hearing. But also, if there's a party breaching PO1, it's easier. You cover your back better if you have a fairly granular PO1. So those are maybe my 2 cents on this issue.
Gisela, what advice would you like to give? Would you like to add anything?
I think that advice was excellent. I want to spin it a little bit, because one of my experiences was a really, as it often, at the beginning of my career as an arbitrator, it's difficult enough as it is, and then which actually makes it quite difficult, because of course the main challenges is, as has been alluded to already, that you have to treat both parties equally, but of course you still want to arrive at an award that takes into account what has been pleaded by both parties. As Lauren said, you cannot make one party's case, but on the other hand, you must try somehow, I think, still to level the playing field to the extent it is possible. And the experience I wanted to share was a situation where I could not remedy the problem there was in the self-represented parties' pleadings by asking questions. Because had I asked questions, there was a concept under the applicable law that had not been pleaded by the self-represented party. I knew it existed. The represented party knew it existed, but under the applicable law, it was also so that I could not base the award on that issue since it hadn't been pleaded, but I also could not ask specific questions enough to, provoke the self-represented party to rely on that circumstance or that legal concept without risking my impartiality and independence. And that was tricky because it led to a situation where I had to arrive at the wrong conclusion under the applicable law, since the right concepts hadn't been pleaded. So I had to render an award that was wrong on the merits. It was procedurally right, but wrong on the merits. And of course, then one issue that I was thinking of is sort of how can I communicate to the parties and to the institute that's going to read my award that I realize this is wrong, but this was the only thing I could. So that was a pretty tricky situation, and I think it's pretty typical. A typical example of where you can end up as an arbitrator. I still think I did the right thing by not, asking. I could not have asked for that information. But what I also did was I wrote, in my award, it has not been pleaded that so and so, which was a clear signal to anyone who read the award that that's the reason why it was wrong on the merits.
Thank you so much for your answer. And I think it was very important to make a difference between guiding a party regarding the procedural issues and not guiding too much to, avoid making the party's case for their behalf. So there's also another very important thing that we need to discuss, I think, based on your answer, because we discussed the delicate balance of guiding the party. And there's another very important task of the arbitrators, as you mentioned, which is drafting the awards. And Gisela, what advice can you give to arbitrators sitting in a pro se arbitration regarding drafting the award, especially if they have faced similar issues during the course of the arbitration?
I would give the same. I mean, drafting an award in a pro se arbitration requires a little bit more diligence than, you know, in a normal represented arbitration, just like drafting an award in an arbitration with a non-representing party also requires extra diligence. And my advice would be to try to be fairly specific also in the award on any sort of issues that, you know, where it is clear that, you know, the issue has been influenced, or the way the issue, either the way the proceedings were run, or, you know, any procedural decisions you made against the self-represented party, or then if you have to arrive at an end result that is wrong on the merits. I would write that fairly specific, you know, specifically in the award, also to sort of be clear on why certain things have been done in a certain way.
Thank you so much for this great advice. Lauren, would you like to add anything?
I think what Gisela said was pretty accurate. From my experience, I would say just go through everything that has been pleaded, everything, all the evidence that has been submitted, go through it very, very detailed in the award. And then, yeah, as Gisela said, make sure that you say, if there's something that hasn't been pleaded that should have been, just say it has not been pleaded that, or it has not, this evidence has not been submitted, just to cover your own bases.
Thank you so much. Normally, I have another question, but I will save it for our Q&A session because we are running a little bit out of time. So with that said, now I would like to thank both of our speakers for this incredibly insightful session. I'm sure most of the participants took notes of your valuable advice. And I know for a fact that I have personally learned so much from today's episode. And it's even more valuable because it is so difficult to find this know-how by an online search. So thank you so much for sharing your experience with us. Finally, we would like to thank our partner organizations, ERA Pledge and Lagos Chamber of Commerce International Arbitration Center, for their invaluable support in making Season 3 possible. And we are truly grateful to the many organizations that support the marketing of our series around the world. For those of you who are watching us over YouTube, our video ends here. Thank you for joining us. To see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel on YouTube. And we would like to hear your comments and feedback, and you can register for our next episode on our website, www.arbinbrief.com. We look forward to seeing you there.